Hi friends, I am your friend Advocate Namish Nigotia and you are watching my YouTube channel Legal Advice for Everyone. Friends, during the course of litigation, during the pendency of a suit, many times it happens that your lawyer could not attend the case personally the date of hearing which has been fixed by the court. There can be many reasons that the lawyer, your advocate, is not appearing. One of the reason may be he is also human being, that he may not be feeling well, or due to some contingency arises in his family, he cannot attend the court on that date, or lawyer may be out of a session because of some urgent work, or you have not paid the fees to your lawyer as per your agreement, or there may be reason that the lawyer is arguing case in another court. In that circumstances, what should a litigant do and how to attend the case and how to seek an adjournment? In this video, I would like to discuss this topic. Before I start my video, I would like to request that if you like my videos, please do like and share my videos, and if you have not subscribed my channel till the date, I would like to request that please subscribe my channel. Friends, first of all, before attending the court date in person, you should know the details of the case. What type of case it is? Is it a civil suit or a civil miscellaneous appeal or a civil regular appeal or a application or a writ petition? First, you should know the type of the case. Then you should know the case number and title of the case, and that should be a correct case number and title of the case before attending the court. Then you must know the stage of the case, because the case is fixed step by step on various stages like service of notice, filing of reply, filing documents, framing of issues, plaintiff evidence, defendant's evidence, arguments, orders. So before attending the court date, you should know that today the case is fixed for what purpose or at which stage our file is going on. Then you should attend the case at the correct time. Generally it starts 10 or 10:30 o'clock, so you should reach before the honorable court at the correct time, and then look at the cause list. So you can see the cause list on internet. It is also available on the internet. Otherwise, on every court they used to affix the court note the cause list outside the court premises on the notice board. So you should look at the order cause list, and you should note your serial number and case number. Then you should enter in the court premises, and don't forget to switch off your mobile phone. Then wait for your turn, because the court may take the case one by one, turn by turn. So supposingly your serial number is 50, so you have to wait patiently till your serial number reaches on your turn. Then whenever your case reaches, you should request to the honorable judge in a humble manner that, sir, today my case, this is my case, I am a litigant, I am appearing in person, and due to certain reason today my lawyer could not appear in the court. And you have to mention the valid reason, and you have to be honest with the court while mentioning the reason. And you should make a humble request that, sir, kindly adjourn the case, and on next date my lawyer will attend the case. The court may ask certain facts that who are you, what is the stage, what is the issue involved in the case. So you have to answer all the queries raised by the honorable court. Then you should request that, sir, today kindly adjourn the case, and I'll definitely comply the orders of the court, whatever the orders of the court will give. The court may give any sort of direction or order. On the next date, you have to comply that order. But you should remember that adjournment is not your right. It is a discretion of the court. What is the legal provisions of seeking an adjournment or adjournment of the hearing of the case? So Order 17 Rule 1 of the Code of Civil Procedure says about the adjournment. I would like to read Order 17 Rule 1 of the Code of Civil Procedure. It says, court may grant time and adjourn hearing. The court may, if sufficient cause is shown at any stage of the suit, grant time to the parties, or to any of them and may from time to time adjourn the hearing of the suit for reasons to be recorded in writing. What does it mean? It means, friends, that if sufficient cause is shown to the court may adjourn the hearing and give the next date, and the court may record the reasons for adjournment. But simultaneously, Order 17 Rule 2D is also very relevant and important. What it says: where the illness of the pleader or his inability to conduct the case for any reason other than his being engaged in another court is put forward as a ground for adjournment, the court shall not grant the adjournment unless it is satisfied that the party applying for adjournment could not engage another pleader in time. It is very relevant. You cannot seek an adjournment by way of your right. It is totally discretion of the court. But if you say to the court that, sir, only today morning I came to know that my lawyer is not feeling well, and due to short span of time I could not engage any other pleader, so kindly adjourn the case. And if court finds that it is a valid ground and it is a valid reason for adjournment, the generally court adjourns the case and you will not find any difficulty. But if you do it as a repeated habit, the court may not adjourn the case and proceed further with the case. After adjournment, the Honorable Presiding Officer generally says adjourn. After adjournment, you just go to the clerk or court master sitting in the courtroom and wait for your turn. He will provide you the next date of hearing. Ask them to show the order sheet, whatever the order sheet has been written, and request that, sir, may I sign the order sheet, and try to sign order sheet on that date. Try to read carefully whatever order has been given. It is a simple adjournment or honorable judge has given any sort of direction. If any direction has been given, you should note that direction carefully so that it could be complied on the next date of hearing. In this manner, you can seek party in person, seek an adjournment, and be careful that whatever date, next date has been given, you should note it down on your diary or file correctly, and on the next date do the compliance whatever the order or direction has been issued by the honorable court. Generally what happens, friends, generally court grants the request of the party and adjourn the hearing, but you should not misuse the procedure of adjournment. And if the court finds that the other party is suffering with such an adjournment, the court may impose some cost. You have to pay that cost, and then the court may adjourn the hearing. So while seeking adjournment, you should be careful that it should not be your repeated habit, number one. Number two, the opposite party should not be suffered. Number three, if the opposite party is attending the case and he is a resident of outstation place outside the town, then the court may impose the cost of his traveling expenses and other expenses. So you have to meet out that expenses also. So if it is a valid reason, the court will certainly help you and will certainly grant an adjournment. Today I would like to conclude this video. Thank you, friends.